probably in the country.
That's true. I mean, this is really something that's very unique, to have a crowd with such anticipation outside of an appeals court. I mean, the closest analogy I can draw to this is some of the early capital punishment cases, death penalty cases, where you had opponents and proponents of capital punishment outside of the courthouses as appeals were being filed to try to get stays of execution. But in a case like this, I've never seen anything. Customarily at the Supreme Court level, when they call you and tell you the opinion's ready, you can walk over there and you don't have to walk past anybody to get in the door.
Now, in the verdicts that we have heard, and in all of the legal proceedings leading up to this moment, is it legal precedent that is being set here, or is it that this case is so unique and so different that it is going to eventually be looked upon as not precedent setting?
Well, I think it's probably will be precedent setting for a couple of reasons. First of all, when we have our next presidential election contest, which following pattern being about another 140 years, but certainly would be precedent for that. But more seriously, more likely, what these decisions have done have been to reaffirm some really basic principles of the right to vote in Florida, how to handle absentee ballots, how canvassing boards are to proceed. And I think that's going to give us a lot more guidance. We've got some sort of updated case law now that these decisions have been rendered after amendments to the statute. So I think you're going to see Gore v. Harris cited in a lot of election cases in Florida for years to come.
And the attorneys that await the verdict, again, what goes through your mind? What are you feeling, particularly when we're talking about a Supreme Court as it is here?
Well, certainly you're saying, I hope I won. And then the second thing you're saying is, I hope it's over so I can take some time off. I need a rest.
Do you go back and review in your mind the arguments, what you said, what you wish you should have said?
Oh, certainly, and that's going on now while they're waiting, and that's probably really more true of the side that loses. And they say, was there something I didn't say that, had I said it, would it have made a difference?
We saw in the oral arguments when they were presented that there was not a great deal of time on the part of the lawyers to get out a formal statement, that they were being hit from the bench right away with questions. Mm-hmm. What does that do to your framework? You obviously go into the courtroom with a whole mindset of how you want to proceed, and suddenly, right off the bat, you're hit with a question, and does it throw you?
Well, it can throw you, and the way that Chief Justice Wells asked that first question of David Boies yesterday, where, like I said, he barely got, the first words out of his mouth, that can throw you. Basically, what you do for oral argument, you're not going to get to talk the full 30 minutes or however it is. You basically write down, I want to make 2, 3, 4 points, get those in somewhere during the questioning, and just make sure that you've got some way to segue into your answers to that. You actually get more nervous. At least my experience has been, if you're before an appellate court and they don't ask you any questions, then you really worry. You'd rather get questioned a lot.
Mm-hmm. Well, tensions are high. Questions are being asked. What is the verdict? We should find out shortly, we believe. But in the meantime, let's go back to Natalie in Atlanta.
Martin, thanks. We're a couple of minutes away from hearing from the Florida State Supreme Court. Let's send it up to Washington. Inside Politics' Bernie Shaw is going to talk with Greta Van Susteren and Roger Cossack. Bernie?
Hi, Natalie, thanks very much. The scene there on the steps of the Florida Supreme Court in Tallahassee, Florida. We can see the state troopers and the court security officers in plain clothes. We understand that the court spokesman, Craig Waters, will be out very, very shortly at 4 o'clock. That's roughly 1 minute, 45 seconds, more or less, maybe 1 minute, 15 seconds. CNN legal analysts Greta Van Susteren and Roger Cossack are here. Greta, Roger, what's going through the minds of the lawyers for both sides right now?
I don't know. Their hearts can be fluttering so fast, Bernie. I don't think they have much going through their minds because this is high risk for both sides. Neither side knows who's going to win, but they certainly are terrified that they're going to lose. It's a lot more fun to win, and the stakes are indeed very high.
I think everyone knows here that this is the last hurrah, and with that in mind, the stakes are enormous. Who's going to be the next president of the United States? I mean, this next court decision very well could tell us. So with that in mind, the lawyers, who knows how fast their hearts are beating, or who knows if they even have a sense of the history.
Well, what about the pressures these justices on this highest court in Florida have been under?
Well, of course they've been under a lot. Plus, you've had this sort of added attraction, so to speak, is that they've gotten a little bit of a smack by the U.S. Supreme Court earlier in the week, where the United States Supreme Court basically said, hey, you're the highest justices in the state of Florida. We can't figure out what you wrote or why you decided what you did. So you've got sort of the added pressure is that the highest court has told them that they need to work a little harder.
Mm-hmm. I think there's also, I'm always struck by the notion of how you wake up one day and you find yourself in the center of history, in the center of decisions that you never thought would come down to you having to make it. And I'm just sure that all of the justices on the Supreme Court right now, as the lawyers, are looking around and wondering, how did this happen to me, and am I going to be able to write the opinion, to make the decision, to do the right thing? How will history treat what I have done? I know if I was in this position right now, the notion of what I was doing would be overwhelming, thinking about the future of the country.
Remember, too, that this may, I mean, this is a significant, Vice President Al Gore needs to win this to stay in the race, so to speak, because it doesn't necessarily mean he's going to win. It just may mean that he could have a manual recount. It may very well be, if there is a manual recount, that he won't win. But having said that, even if Vice President Al Gore does win, there's a chance that Governor Bush will take this on to the United States Supreme Court. So while we think this is maybe the end, it really isn't the end. It's a must-win for Vice President Al Gore. It's not a must-win for the governor.
Spokesman for the Florida Supreme Court. The court today has issued its opinion in the case of Albert Gore Jr. versus Katherine Harris, George W. Bush, and others. Paper copies of that opinion will be available here at the front door as soon as possible after I finish this statement. The opinion also will be posted on our duplicate websites as soon as possible. The court has authorized the following statement. By a vote of 4 to 3, the majority of the court has reversed the decision of the trial court in part. It has further ordered that the Circuit Court of the Second Judicial Circuit here in Tallahassee shall immediately begin a manual recount of the approximately 9,000 Miami-Dade ballots that registered undervotes. In addition, the Circuit Court shall enter orders ensuring the inclusion of the additional 215 legal votes for Vice President Gore in Palm Beach County and the 168 additional legal votes from Miami-Dade County. In addition, the Circuit Court shall order a manual recount of all undervotes in any Florida county where such a recount has not yet occurred. Because time is of the essence, the recount shall commence immediately. In tabulating what constitutes a legal vote, the standard to be used is the one provided by the legislature. A vote shall be counted where there is a clear indication of the intent of the voter. Chief Justice Charles T. Wells and Justice Major B. Harding have written dissenting opinions. Justice Leander J. Shaw, Jr. has joined in the dissenting opinion of Justice Harding. Thank you.
This historic ruling just announced by the clerk of the Florida Supreme Court, Craig Waters. Greta Van Susteren and Roger Cossack, a very complicated ruling, but the vote was 4 to 3.
Well, and it's a very decisive one. And this one gave a roadmap. This was not just one of those vague decisions where a courts give sort of lofty principles. This one has clear directions. A hand count is to begin immediately. It says it talks about the votes that must be added. This is a clear directive. These are instructions to the lower court. This is not an announcement of principles of law.
And did we notice Craig Waters underscoring the standard, and he said, we are using the Florida state standard for counting votes. He said, a vote shall be counted where there is a clear indication of the voter's intent.
And you know, Bernie, that is the Florida state standard, and to me, I think they've just opened up a big morass again, because the notion of saying whatever the intent, I mean, people have been saying, what is the intent since this thing began? And the idea, is that the dimple Chad? Is that the punch Chad? Is that the one-corner Chad? I just think this is a difficult issue, and by just a second, and by one vote, as 4 votes to 3, we are now going to go through this again. I support the Florida Supreme Court. I support any court. I'm just honestly very surprised at this decision.
Here's why the intent isn't so unusual. The Florida Supreme Court's supposed to interpret the law of the state. The statute says you're supposed to determine the intent. That's what the legislature directed, and that's what the Florida Supreme Court is merely echoing what the law said. But more importantly, remember, in cases every day, day in and day out in courthouses, people are determining the intent of actors, whether it's a criminal case. I mean, this is not so unusual or so bizarre. And I know that there's been a big push to try to have it, defined in sort of scientific terms, but I don't think it's unusual.
Jeff Greenfield, your thoughts? Jeff will be joining us shortly from New York. Roger?
Yes, Bernie, I understand what my partner has said, and certainly that is the argument that lawyers are instructed to look for, or judges ask juries to look for intent in all things all the time, and based on evidence and things that they hear from the stand. I think this is a different situation. I think this is looking at cards. We all remember Judge Burton holding that card up to the sky and trying to make some kind of a determination.
But Roger, that would
and
be writing the law.
and I think that it just becomes a difficult situation. Now, having said that, the Florida Supreme Court says they can do it, and I suppose that's what they'll have to do.
Here's the problem with that, Roger, is that one of the big gripes about the Florida Supreme Court is it was inventing law. We had that big discussion in the Supreme Court about the deadline, and what the Florida Supreme Court is supposed to do is be strictly construing the statute. That's what the statute says.
The statute is meaningless. Yes,
I want to go to this area. We had been saying for days, noting a reviewing court's reluctance to overturn a lower court ruling. But you've got a very interesting dynamic that was underscored in a front-page New York Times piece today. Judy Woodruff pointed it out to me about Judge N. Sanders Sauls and his run-ins with the Florida Supreme Court. His being a very strict constructionist. And here's a case where this Florida Supreme Court has once again reversed this judge.
But we don't know why they reversed it.
Yeah, that's the other side of this coin.
Yeah, we have no idea why it is at the Florida Supreme Court. We only know it's happened. We'll get the decision within minutes.
We don't know yet why he actually reversed it, why the Supreme Court reversed it, what they based their ruling on, and what they came about, and whether or not they've answered the United States Supreme Court's question, because get ready, United States Supreme Court, we may be up to see you again.
How about that, Jeff Greenfield?
Yes, folks, here's my first reaction. If you do not like political chaos, it's about time to head for the storm cellar. Because, first of all, up until about a few moments ago, I think most people were expecting the Florida Supreme Court to kind of go along with Judge Sauls and bring this to an end, and people were drafting Al Gore's concession speech. Second, while we are talking at this moment, the Florida State Legislature is in session, and everything we know about that is that they are fully prepared to allocate those 25 electoral votes to George Bush if this isn't wrapped up by December 12th, which is 4 days away. And the third point is, by one calculation I just read before this decision was announced, if they have these teams of counters counting these ballots 24 hours a day, it could take them 5 or 6 days to do them, which takes us past the December 12th deadline. And the last point I would make is, by coincidence, I had lunch yesterday with Judge Burton down in Palm Beach, and he was describing how tricky it was to look at these ballots one at a time and discern voters' intent. It sounds like a standard, right? But it's not a standard like two corners hanging, 3 corners hanging. So between the furious reaction on the part of the Republicans, who once again thought they had it won, the state legislature, the likely appeal to the Supreme Court, and the December 12th deadline, I mean, you talk about a melodrama that just keeps building on ending after twisting turn. I mean, if somebody tried to design the political equivalent of a thrill ride at a theme park, they'd shut this down as a threat to the cardiac health of anyone who'd ride it. It is simply unbelievable, except it's happening.
Well, within this melodrama, there's the savoring of victory. Kate Snow in Tallahassee. The Gore lawyer's reaction, Kate.
Bernie, I just talked to some members of the Gore legal team, one actually, but he tells me that the room went wild when this ruling came down. They were all sitting here in their office in Tallahassee. There was cheering, there was loud clapping as soon as they heard this ruling from the Supreme Court. David Boies was in the room. I also understand that they just got a phone call from the Vice President, Al Gore, telling them congratulations, let's get counting, let's get started on this. Certainly a lot of happy faces in that room. They did not, you'll note, they did not get the recount that they wanted of the Palm Beach County votes. If I understood correctly, and I believe I did, Craig Waters just said they will recount the 9,000 Miami-Dade ballots that are in question, but then he did add that they will recount in any county that has not yet done a manual recount. So in some ways, in some sense, going even further than what the Gore team had asked for. Bernie?
Okay, Kate, I thought I heard, I may have misheard him say that upwards of 300 ballots in Palm Beach. I could be mistaken. I'll go back and check.
Let me try to clarify that, Bernie. I believe what Craig Waters said is that one of the requests from the Gore team was, please add to the final tally from Palm Beach County those 215 votes that they call legal votes that were counted after that deadline. You'll remember that night, that Sunday night on November 26th, they were trying to finish counting. They finished a little bit late. From what I understand, they will add back in those 215 legal votes, or that's what they called them, legal votes in Palm Beach County. They will add back in 168 votes to the Miami-Dade count. But in addition to that, they will take another look, or they will ask someone to take another look, the circuit court to be exact, to take another look at those 9,000 Miami-Dade ballots, in addition to ordering counties that have not yet done any manual recount to begin counting now. Bernie?